All right, my friends, I just pressed the Let's Go Live button. So let's wait for the stream to fire up all across the fruited plain of this beautiful interwebs that we're communicating across today on this lovely Friday. We got to make sure the tubes are working. Sometimes we start rambling off here and they're not even connected, and done that once or twice. Not a real good feeling there. Uh-oh. But it looks like we're working. We're on the Rumbles. We're on the YouTubes. We're on the X. We're on the locals. We're everywhere, my friends. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about the Trump trials. We've got 3 of them to attend to today, and there was some spicy stuff going on. We're going to start with Washington, D.C. Judge Chutkan is the one that we're talking about. Now, this is in the January 6th case, and of course, we've got some business to attend to here. Donald Trump filed an emergency motion for a stay in the Court of Appeals in the DC Circuit. And my friends, like 10 seconds ago, I just found on the X platform that the court has actually granted the stay. All right, so we're going to go through that and see exactly what's going on there. So we'll read the motion. The court has granted it, and we'll see exactly what happens next. But Trump also released a gag order statement, and he says, you know, this is tantamount to election interference because what's happening is they are stopping him from criticizing one of the main issues of the 2024 campaign via this gag order. Now, they're saying that he's just being gagged from interfering with this criminal proceeding, but the commentary, the free speech, is about the proceeding, and the proceeding itself is a campaign issue. So what gives? How does it unfold? We're going to hear about that today in the emergency motion for a stay, and the Court of Appeals has granted the stay, which means Trump is probably going to be saying something about this, and so we'll be having to check his True Social account as well now that the gag has been lifted. So we'll go there. Then we're going to talk about this woman. Her name is Allison Greenfield, and we're calling her here today Engoron Greenfield. He's just in love with her. He calls her my GF, my Greenfield. And look at him. He's just looking at her like, hey, baby, what's going on? Of course, she's the law clerk who is seated in the courtroom alongside, and she's been gotten some critiques about her performance there. Why is she constantly handing him notes, whispering him a bunch of garbage? She's not the judge. The judge is like, I don't know what to do. Objection? I don't even know what that means. The judge is like, what year is it? So she turns over to this person who may or may not be Chuck Schumer's girlfriend. I don't know. I've heard a rumor about that from Trump, I think. And it is a strange thing that's going on. So we'll go through it. But he's looking at her side-eye. Now, he gave her a lot of protection. He says, don't you dare talk about my Greenfield, and issued a gag order that we'll read through. This was the one that is going to go against not only Trump, of course. Trump can't talk about Greenfield, the judge's Greenfield, but he can, or now, not even Alina can talk about Greenfield, or Christopher Keyes can talk about the judge's Greenfield. So it's just this interesting thing. We'll read through the gag order. Eric Trump was also testifying today. We're going to poke around inside the courtroom and see what's happening there, because there was a moment when he stepped out, made a statement, and we'll hear from Eric Trump, of course, the president's son as well. Now, we'll go in there. It was a short day in trial, actually, so we'll check in with Dan Alexander, 21, over on the X, along with Adam Klasfeld on the X. It was very spicy. It was all about Judge's Greenfield today. Oh, I love her, or whatever. And so, it was about the gag order. And then they kind of wrapped up. You know how these things are. It's Friday. Everybody's like, oh, my kids have a ceremony, whatever, stuff is going on. So we'll go into that. Now, we've got a clip from Alina, Habba, who's in the house. And man, she's fired up. All right. She was out there on the steps of the court, just letting it rip. And it was just a lot of fun to watch. She's fired up. So we'll get into that. And then, of course, today we also had a third Trump trial that was well underway in Colorado. And in Colorado, they're trying to keep Trump off the ballot, these little cheaters. They don't actually want to run against him in the election. So they're just like, how about we just kick him off because we're scaredy cats. And so they're trying to do that. And they brought this guy in. His name is Tim Heaphy. And when we get here on this segment, I want to hear from you and see if you think about, like, does he look like he's a little extra squirmy? He's pretty calm during most of the testimony today, but then he gets a little bit squirmy. You know, he's doing the old scratch of the head. He's doing the old, and look, we sit here. I sit here in a chair for a while, and so I can squirm around. I get it, but he's getting a little squirmy there, right? And the squirmy comes around when he gets asked some pretty interesting questions about the so-called nonpartisan, non-biased January 6th Select Committee so-called members who were there investigating Donald Trump. It's actually a fun kind of exchange because he just pulls up Raskin's statement, Schiff's statement, Aguilar's statement. He's like, does that sound like an unbiased person to you? Huh. No wonder he's squirming around there. So as you can see, my friends, we've got a lot to get to today, and we're excited to dig into it with you. We had a great comment come in already from our friend Quarter Native. He says, my friends, find someone who looks at you the way Engoron looks at Greenfield. That's right, my friends. If you can find somebody like that in your life, right, who just gives you that nice little stare, it's like, hey, I'll do anything for you, including prosecute my political opponents and wreck America, baby. So, all right. So good stuff. Now, we have a lot of fun on our locals community, and of course that came in from Quarter Native over there, and super funny. So we had a great member stream this morning, and today we talked about Mayor Adams. All right, Mayor Adams was flying over to Washington, D.C. He's the mayor of New York, and he gets his phone call from probably his girlfriend or somebody, I don't know. And then they're like, hey, she's getting raided by the FBI. So he's like, oh, hey, baby. He tells the pilot, turn this puppy around. They fly back over to New York City because I think she made like $2.5 million for him or something. We talked about that this morning. A lot of fun. Then we also talked about J.D. Vance, who's got a little interesting strategy there in the Senate. He's saying that there's no more DOJ nominees coming through the Senate. Not on my watch, says J.D. Not unless you stop your funding of these Trump prosecutions. And so we talked about all that this morning on our locals and members only streams. You can become a member on YouTube. You can become a member on locals. The web address is watchingthewatchers.locals.com. Great place to go. And we have a great community there. A lot of fun stuff. We also do after parties. So when the show is over today, we're not going to be done quite yet. We're going to hang out on locals. And so if you're a YouTube member, you get all the same things except the after party. You're going to have to grab the Telegram link. Join us on Telegram after the show is over. We've also got robertgovea.com. So click on over here. If you want to read the reports, if you want to see the PDFs, if you want to access the mind map, all the resources are at robertgovea.com. So you can get the daily reports. You can go right here, click the reports section. Everything that we talk about, we publish, make summarized, add the PDFs to it so you can access it. And so it's chronicled. It's etched on our own servers that are not going to be deleted or removed. You can also access the mind map. Just click the mind map tab, enter your name, boom, it should come right across, and there's a little tutorial on how to use the mind map. So you can access the PDFs that way as well, and there's a lot of other good stuff coming down the pike. So check it out, robertgovea.com, or you can get there watchingthewatchers.tv if you want to check that out too. So you can head on over there. We're also going to have a couple of live stream privilege inserts for our friends at ground.news/RGE. If you're looking for a real cool news app, that is it. It is cool, and you'll see the promos if you watch the segments, but since you're here on the live stream, we're just going to fast forward through them and exercise our live stream privilege here on the stream. And so, let's get into it, my friends, because we also have, yes, that's right, we also have the update from the Court of Appeals, so we're going to make sure we don't miss that. Starting now. Donald Trump files an emergency appeal with the D.C. Circuit Court of Appeals, and it has been granted. Good news for Trump. That means he's not gagged. His free speech is back in play for a very limited amount of time. Now, we're going to go through the actual motion because I'm not so sure that this stay on the gag, meaning the lifting of the gag, I'm not so sure how long it's going to stick around. The D.C. Circuit Court of Appeals, the people who drew the Trump case, are all lefties, Obama and Biden appointees. And so this stay might be very temporary. And so we want to see what Trump's arguments are, because I truthfully believe that this is going up to the Supreme Court. At some point, they're going to have to step in and settle this once and for all, because we've got Trump's free speech rights in the middle of an election where he's the leading candidate versus the so-called local rule in the D.C. courts, Judge Chutkan saying, I have the right to protect my proceedings. We've got the judicial due process and the sanctity of a criminal court versus the free speech rights of a political candidate, and not to mention not just him, but all of us the tens of millions who support the man, who want to see him be given a fair shake and be able to comment on a partisan political prosecution coming down against him. So we're going to take a look at the Court of Appeals order that has issued the temporary stay, meaning that the gag order has been lifted temporarily. But first, before we get into any of it, Trump issued a statement about this contemporaneously with his emergency motion. So we're going to read through both of those, starting with Trump's statements, because this is what he is saying, framing out what the effort here is. He posted this. He says, hey, here's the statement on the filing of the emergency motion to stay the gag order, to stop the gag order that's already been in place. They say here, Stephen Chung, spokesman for the campaign, writes, no court in American history has imposed a gag order to silence any political candidate until now. The district court's unconstitutional gag order prevents Trump, the leading candidate for president of the United States, from engaging in core political speech, which is entitled to the highest level of protection under the First Amendment, saying the Biden administration chose to indict President Trump in the middle of a campaign season in a politically motivated attempt to derail his candidacy, and the First Amendment allows President Trump to speak out against this unconstitutional tyranny. Indeed it does. Now, worst of all, the gag order violates the civil rights of over 100 million Americans who follow President Trump and have a First Amendment right to receive and listen to his speech. The voters of America have a fundamental right to hear the uncensored voice of the leading candidate for the highest office in the land. Today, President Trump has filed an emergency motion to halt the gag order in the U.S. Court of Appeals for the D.C. Circuit. The Court of Appeals should immediately stay the unconstitutional gag order and speedily reverse it. You can read the full motion here, which of course we'll do. Spokesperson who filled this out is Stephen Chung. And so now let's pause and pull up the actual order, because I did see the order come out. And so since this just broke, it's fresh out of the oven. I know I saw it coming from our friend Julie Kelly, and you can follow Julie Kelly and the great work that she does on the X platform. Now, here is what she says. The Court of Appeals has granted the temporary stay. And you can see this from Julie Kelly at Julie_Kelly2, saying, look at this. An all-Dem 3-judge panel for the D.C. Appellate Court issues a temporary hold on the Chutkan gag order, and they're actually expediting the appeal process. So we're going to come back on this on 11/20. And so we're going to read through the actual motion from Trump, and then we'll hear the oral arguments on those motions later. Here, the case is United States of America versus Donald Trump. The order from the Court of Appeals, you see the 3 judges there. I think 2 were from Obama, 1 is from Biden. Millett, Pillard, and Garcia. They say here, all right, we've reviewed Trump's motion, and upon consideration of the emergency motion, which we'll get to, which includes a request for an administrative stay, right, just a temporary pause administratively, to expedite the appeal, it is ordered that the district court, Chutkan's order, be administratively stayed pending further appeal, pending further order of the court. The purpose of the stay is to give the court sufficient opportunity to consider the motion for the pending appeal, right? It's just like, hey, everything is on hold. Everything reverts back to the beginning like we just started, just while we're looking at things. But then they're going to look at things, prediction, and say, oh, Trump, oh gosh, he's threatening everybody. And then they're going to come back down and say, Chutkan, that was a brilliant move. You're so smart. And it's going to say here that it's not going to be construed in a ruling on the merits in any way, shape, or form. So just hold your horses, right? Now, they say it's further ordered. This appeal is going to be expedited. Absolutely. Obviously, we've got an election we're talking about right here. Every day Trump can't talk about this scam charade prosecution is a victory for them. Now, the following briefing schedule will apply. They say November 8th, give us some motions, joint appendix due by the 8th, appellee's brief and the reply brief by the 17th. So we're going to hear from the government, then we'll hear from Trump. Further ordered, this case is going to be scheduled for oral arguments November 20th, 9:30 a.m. Separate order will issue. Appellant should raise all issues and arguments to enhance the clarity. Please limit the use of abbreviations, blah, blah, blah. So that's from Julie Kelly. Great work and a great follow from her. So that is what we see happening now. Let's get into the actual order itself, because when we arrive back there in November 20th, They're going to be arguing this motion, and what's going to happen is the government will submit their response, and then Trump will issue his reply, and then the court will have oral arguments, and we'll see what they do about this. Trump's free speech and our right to engage in a political candidate's conversation, to engage in free speech ourselves and exercise our rights under the First Amendment, all at stake in this case. 35 pages. We're going to hit the highlights of it. You see, United States of America versus Donald Trump, and Donald Trump is the defendant appellant, so he is saying, I'm unhappy with the lower level ruling. We'll fly through the table of contents. We'll see that there are some nice substantive arguments here, and we'll get to all of them. Now, they say, as we scroll down to the very beginning, past the table of authorities and the glossary, starting off, Trump's team writes, and again, this is in the criminal case, January 6, Judge Chutkan, District Court in D.C. on appeal to the D.C. Circuit Court of Appeals. Trump's defense writes, all right, Court of Appeals, let's get real. No court in American history has imposed a gag order on a criminal defendant who's actively campaigning for public office. Never. Let alone the leading candidate for the President of the United States. That centuries-long practice was broken on October 17th when the District Court, Chutkan, issued an order called the Gag Order, muzzling President Trump's core political speech during a historic presidential campaign. Writing, given the gag order's extraordinary nature, one would expect an extraordinary justification for it. Yet, none exists. President Trump has made months of public statements about this case, but the Department of Justice, aka the prosecution, submitted no evidence of any actual or imminent threat to the administration of justice. Instead, when asked about the supposed threat to the case, the prosecution admitted, quote, of course, this prejudice is speculative. Then, based on this speculation, the District Court, Chutkan, entered a sweeping, viewpoint-based prior restraint on the core political speech of a major presidential candidate, based solely on an unconstitutional, quote, heckler's veto. The gag order, Court of Appeals, violates the First Amendment rights of President Trump and not only him, but over 100 million Americans who listen to him. President Trump's uniquely powerful voice has been a fixture of American political discourse for 8 years and central to the American fabric for decades. The prosecution's claim that his core political speech suddenly poses a threat to the administration of justice is baseless. The prosecution and potential witnesses addressed by President Trump's speech are high-level government officials and public figures, many of whom themselves routinely attack President Trump in their own public statements, in their media interviews, and their books. Now, President Trump's viewpoint and modes of expression, they resonate powerfully with tens of millions of Americans. And so the prosecution's request for a gag order bristles with hostility to President Trump's viewpoint and his relentless criticism of the government, including the prosecution itself. The gag order embodies the unconstitutional hostility to Trump's viewpoint, and it should be immediately stayed. They write, President Trump requests a ruling on this motion by November 10th, and they got one. And they got the administrative stay granted. They say, we've notified the government, deranged thug prosecutors over there at Jack Smith's office, who note that they oppose this motion, and President Trump respectfully asks that we expedite this appeal, which once again has been granted. They give us some facts on the case. They say, all right, Court of Appeals. President Trump, as you know, is the leading Republican candidate in the United States of America. He has a dominant lead in the primary polls for the Republicans, and he substantially leads Joe Biden in head-to-head polls. Trump has over 100 million followers across social media platforms. And on August 1st, Trump was indicted for 4 counts related to his disputes of the 2020 election, which he and millions of us believe was rigged and stolen. Now, as this case proceeds, President Trump continues to campaign for president, and he frequently talks about this case, including using core political speech. His central campaign messages include statements that this case is a politically motivated persecution designed to derail his candidacy. it's one of the top issues, if not the top issue. We woke up in America where we used to not have political prosecutions of our opponents. Now we got 4 of them criminally and many others civilly. He's saying legally that the prosecutors are abusing him and abusing them, their power against him. He also criticizes major public figures connected to this case, and he recently criticized the Biden administration for neglecting national security threats while allowing D.C. to turn into a dumpster, crime-ridden embarrassment to our nation. Saying, on September 15, 2023, the prosecution moved for a gag order on President Trump's public statements. And they said, you know, in the period between November 3rd, 2020 and January, almost 3 years ago, they said Trump made statements about individuals, and those individuals were subject to threats and harassment. Now, their examples of this threat and harassment were from late 2020, really reaching into the past. The most recent public statement by Trump that was supposedly followed by threats was from December 2020. It's 23. The prosecution then provided 10 screenshots of social media posts by Trump since his indictment. Now, those 5 posts included criticisms of the DOJ and the deranged thugs over there. They included 2 posts about witnesses like Rudy and Mike Pence, who dropped out of the race, which made no clear reference to this case. And the prosecution provided no evidence that any prosecutor or any witness had been harassed or threatened after any of these posts, nor any evidence even that any individual felt intimidated at all. In fact, they presented no evidence of any statements about court staff as well. So then they filed a reply, and they went in and they dug up 6 more social media posts. And they got posts criticizing Pence and Bill Barr and Mark Milley and Brad Raffensperger, the phone call guy. All those mentioned were high government level officials and public figures. The prosecution submitted no evidence that any prosecutor or witness had been threatened or felt intimidated by Trump's comments at all. So the district court, Judge Chutkan, had a hearing back in October, which we covered, and they presented the government no evidence at the hearing. But the court still sat there and repeatedly expressed concern that Trump's comments might inspire independent third parties to do something to someone. They emphasized by Trump's lawyers that there is no evidence. Your Honor, it's all speculative. They haven't presented a shred of evidence. And the court responded, quote, "Why should they have to?" Judge Chutkan's own statements. Why do they need evidence here? I don't know, because this is a courtroom? I don't know. Probably. Maybe. When the district court asked the prosecution about its lack of evidence, the prosecution responded, "Of course, this prejudice is speculative." Yeah, so you don't need any evidence. You just gag him based on speculative prejudice that might happen because some demented people think it might. The defense proposed that the, quote, easiest solution is to adjourn the case. If you're so concerned about the election and about danger and high tensions and all those things, just postpone it till after the election. And the judge said, "Are you kidding me? This is our whole plan. This is the keystone for exactly what we're trying to do here. We need a conviction on January 6th so that we can call Trump a felon, which will then parlay into our Colorado removal attempts, which is now spreading out to other parts of the country, as we predicted. And then from there, they'll also be able to say Trump is a felon and send that over to the Republican Party, and they'll put that up the chain to the Mitt Romney crew there. And then they'll say, well, our rules say we don't nominate convicted felons, especially convicted felons of insurrectionists. And then they'll do the same thing to try to remove Trump out of the party there. So this election, I mean, this trial is not moving, right? They are going to do everything they can, unless the Supreme Court or somebody comes in and something happens that way. But Chutkan, it's got the marching orders, man. Don't move the trial. We need it to happen then. The trial, she said, will not yield to the election cycle, and we're not revisiting the trial date, right? Not going anywhere. The other 2 times that the defense counsel, has raised this alternative, the court again dismissed it, meaning they don't really care about the trial. They care about the trial happening before the election. The prosecution presented no evidence about the availability or efficacy of any other less restrictive means, right? So in other words, they'd rather gag Trump than just postpone the trial, because postponing the trial would also calm things down and presumably protect people until after the election when things are a little bit calmer. Now, the judge on October 17th issued an order and its opinion. They said that we find Chutkan writing unidentified third parties might react to President Trump's speech. She says when the defendant has publicly attacked individuals, those individuals are consequently threatened and harassed. But the gag order cites no evidence, just made it up, and they made no findings of any of those threats or harassment since the case was filed. She just wrote that, in other words. You know, on Wikipedia, it would say citation needed. Okay, like where is this coming from, Judge? Where? Now, the gag order recited that the alternative measures like careful voir dire, which is jury selection. Did you hear Trump, threatening anybody, or did you hear this, or are you going to be biased as a result of what you've experienced related to this case? Anything that they say that could remedy this supposed harm, it's not enough, they say. The gag order cited no evidence, made no other findings, did not mention a trial continuance as an alternative measure, and so the district court issued the gag order, and this is where it really went wild. The whole thing, I think, is unconstitutional, but any reasonably foreseeable witness or the substance of their testimony, no comments on. Now, Jack Smith and the deranged thugs, they can leak all this stuff over to the Washington Post and other entities, and you can see in other cases, like in the New York case, Tish James can post tweets about this stuff, and people can, Mike Pence can hop on and talk about this stuff, or Bill Barr can go on CNN and talk about it, but Trump can't talk about it. Isn't that convenient? So one side has to play an election with their hands tied behind their back and their mouth strapped up. The court included exemptions so Trump could criticize the government generally, like the government is bad. Yeah, vote for me. The defendant is innocent of the charges and that the prosecution is politically motivated, and he could criticize people like Mike Pence, who's not even in the race anymore. Thanks, Judge. President Trump filed a notice of appeal and moved for stay pending appeal. And here the district court denied the motion for a stay. Now, of course, the Court of Appeals has issued an administrative stay. My guess is that's not going to last long. But here's what they say. Your Honor, this is why the gag order is immediately appealable. They tell us the loss of First Amendment freedoms, even for a limited period of time, constitutes irreparable injury. Now, we often talk about criminal cases and how difficult criminal cases are to appeal. And often that's because the appealable issue doesn't impact other rights. So when you talk about collateral consequences, when you think about a collateral consequence, for example, if you get convicted of a DUI, the court might not fire you from your job, right? In fact, it can. It doesn't have jurisdiction over that. But one collateral consequence might be if you have a job that requires you to drive and not have DUI convictions, you're going to lose your job. That's a collateral consequence, right? So in criminal court, sometimes there are just things that happen in criminal court. And if you file a motion and you lose the motion, that witness should be precluded or that evidence should be suppressed or whatever, then that evidence, if the judge makes a mistake on allowing that or to come in or not, or that witness to testify or not, you just say, okay, well, it's not going to impact anything else. We're going to go to the end of the trial and then appeal all of those issues. And then if it is a big problem, then they'll just, do it over again. Just go back and do it over again. But in this case, you can't really do it over again. Okay. If Trump is gagged so that this criminal case goes appropriately, that gag impacts a bunch of other things. Okay. Like what we want to hear from Trump and like what he needs to campaign about, which is a political prosecution in America. So they're explaining that we have an absolute right to appeal this because of the collateral consequences that are extenuating from the order. The loss of First Amendment freedoms, even temporarily, unquestionably is irreparable injury. And so the gag order falls into a small class of different limitations, which are too important to be denied review. Meaning you have to hear this case and rule on it. They say a gag order, as we know, is such a protected right that if you're going to threaten it or take it away, it's going to be subject to the most exacting scrutiny. We're going to analyze the attempt to limit someone's free speech with the biggest microscope and the finest tooth comb you could possibly imagine. As a viewpoint-based prior restraint, limiting Trump before he even says anything, Not punishing him for what he has said, okay? It's muzzling him, gagging him. You cannot talk about these things. Doing that to somebody with an audience of over 100 million Americans who happens to also be a presidential candidate, the gag order is virtually per se invalid, meaning I can't believe she wrote it. It's facially invalid. But if you're going to say that we need to analyze it, all right, let's do it. They'd say it's going to require the most exacting scrutiny. And so we're just going to do it. They say, in this case, Landmark versus Virginia, the Supreme Court held that restrictions on speech about pending judicial proceedings, they require, this is a U.S. Supreme Court case from 1978, good case they found. Here, it requires a clear and present danger to the administration of justice. Clear and present danger to the administration of justice. A little bit different than what Jack Smith was telling us. Somebody might do something sometime somewhere because we have evidence that somebody was threatened in 2020, 3 years ago. Saying the operations of the court and the judicial conduct of judges are matters of utmost public concern, and public scrutiny of court proceedings guards against the miscarriage of justice by subjecting the police, the prosecutors, and the judicial processes to the public scrutiny and criticism that they deserve. There's another case from the Sixth Circuit, and there's another case called Gentili. Supreme Court that held a state could impose different standards for attorneys, but attorneys are not ordinary citizens. Attorneys have different standards. And so this gag order from the First Amendment that limits the First Amendment from Chutkan calls for exacting scrutiny, calling this a prior restraint and saying that political campaigns require the strongest constitutional protections. If we're going to gag people when they're running a campaign, then they're not going to be able to challenge the very thing that they're trying to change, because all of the institutions are just going to say it's illegal to criticize us because we've got to do our job. You can't criticize the CDC because we're saving lives. You can't criticize the military because we're spreading democracy or whatever. Here, the gag order restricts core political speech. You can't talk about the Department of Justice because we're enabling justice. What? The issues underlying the indictment are central to Biden's re-election argument, and the First Amendment permits Trump to rebut those positions and to go after the government officials who are attacking him. They tell us Americans have the right to receive Trump's speech. Now, this is not only Chutkan just trying to protect her courtroom. Okay, she is limiting his ability and presumably his defense team's ability to tell us about the bad actors, to complain and to criticize and to condemn the people who are violating the standards of decency that we believe are standards they don't really care about. And if he can't communicate those things to us, that hurts us. They say the First Amendment protection is afforded to the communication, to its source, and to its recipients both. 1976 case. Recognizing the right to speak and the right to listen. And to speak and listen once more. It's critical to the First Amendment. What if you have the right to speak, but nobody has the right to listen or to hear? Then what good is the speech? A restriction on President Trump's speech inflicts a reciprocal injury on us, the rights of over 100 million Americans who listen to him, irrespective of their political beliefs. Now, this right of the listeners to receive Trump's message has its fullest and most urgent application right in the middle of campaigns. Saying if Congressman Ford were silenced earlier, then people would have doubted the process. They say the gag order has already been widely criticized, by the way, judges. This restricts the rights of voters to hear Trump's message. And if Trump's message is so out of alignment with what most Americans think, then wouldn't Americans just hear that and just vote against him? If that's true? But we know that it's not. Even the ACLU is going to bat for Donald Trump, they said. They said the gag order, even the ACLU is like, what's going on here? Says the public right to hear Trump's views, they have the right. So the public can decide. The public can decide, not Chutkan and deranged thugs in the DOJ. The issue is raised repeatedly, but the judge gave the First Amendment rights of Trump's audiences, that's us, no meaningful consideration. She says, oh, what, those insurrectionists? No, don't care. So the gag order does not even mention them, doesn't even care about the people who might want to vote for him and hear from him, saying the district court declined to even consider them when President Trump raised these issues. And they're saying, that's kind of basic First Amendment jurisprudence here. You got to consider the recipient in your analysis before you gag someone, calling that reversible error. Now, they compare this to a heckler's veto, which we've talked about here. But they say the gag order's justification is to protect trial participants from hypothetical harassment and independent third parties. Now, the court did not hold that anything that Trump said, right, it's not Trump's speech, that anything amounted to fighting words or to incitement, right? He didn't violate. His speech was protected. It didn't jump out of it because it was incitement under Brandenburg. So the gag order restricts Trump's speech based on solely the reaction. It's the classic heckler's veto, when the First Amendment, which the First Amendment categorically forbids, saying the government may not insulate a law from charges of viewpoint discrimination by tying censorship to the reaction of the speaker's audience. Okay, so if you're up on stage and you're saying something and the heckler says, I'm offended by you, how dare you say something that's not politically correct? And then you're in trouble because some heckler stands up and tries to condemn your speech. No. A speech burden based on audience reactions is simply government hostility, and it's intervention in a different guise. You can't say that thing because some people in the audience might be mad. Now, the gag order also, it shields public figures from public criticism, which is our right to do, saying that the gag order silences public criticism of quintessential public figures. These are important people. The First Amendment does not tolerate shielding public figures from this criticism. Now, what's disgusting about this, particularly offensive is their language, is the gag order's one-sided nature. It prevents Trump from targeting, they say, senior public officials like Pence and Barr, who routinely attack him and his fitness for the presidency. Barr's all over the place with Jake Tapper. It prevents him from responding to deranged thug Jack Smith, who has made inflammatory public statements about Trump and whose team leaks all over the place to the press. How do we know that? Because we read the articles here. The government has no such authority to license one side of the debate, and the gag order limits one viewpoint, and the government just simply did not meet the standards. They just did not establish a compelling interest. The gag order is not narrowly tailored. It is just saying, Trump, you're gagged. They didn't even try anything else. It's overbroad because it's based on the heckler's veto, and it prohibits criticizing major public figures who condemn Trump constantly. It's incurably vague, and it doesn't define what's allowed and what's not allowed. And so any clarification makes it even worse. And they say, Your Honors, on the Court of Appeals, if you don't grant this, there will be irreparable injury to Donald Trump. He's going to lose his First Amendment freedoms, and here, millions and millions of listeners are going to not be able to engage. The government doesn't suffer any harm by allowing Trump to speak to us, and public interests are at play here. It's always in our interest to protect the Constitution. And so they say, Court of Appeals, the court should deny the gag order pending appeal. And in addition, President Trump respectfully requests that the court enter a temporary administrative stay pending resolution of this motion and issue its ruling by November 10th. Of course, we already know that they've granted this. The administrative stay has already been in place. This is signed off on by John Lauro and Trump's defense on behalf of Donald Trump. So the stay has been granted. It is going to be temporary, and Donald Trump is now free from the gag order for now, but we'll see what the Court of Appeals does. Of course, we're going to be continuing to cover the January 6th case, and we'll come back and see if Trump has anything to say about it once the news of this has settled across the campaign and the lawyers have time to react. We'll be here covering, my friends. I hope you join us as we do. Thank you for checking out robertgovea.com to sign up for our daily newsletter on our website and get all these segments and the PDFs, links delivered to your inbox, and we'll look forward to seeing you on the next one. All right, my friends. We carry on. And my goodness, I see Dolphin Fan is the man with 50 membos. Woo, Dolphin. All right, so Dolphin, we're going to make sure we get to all those here in a minute. But man, I saw those coming in. So welcome to all the new membos in the house. Happy Friday, my friends. Dolphin, thank you so much. Super cool of you to do that. So 50 new membos. We'll give the proper welcomes here in a bit. But let's get to the second segment on the day. This one with the judge. And it's Judge Engoron and his law clerk, Greenfield, as we know. Let's get to it. Judge Engoron gags Trump's lawyers. He doesn't like their comments about Greenfield, this woman right here. Allison, you see the judge has a little bit of a sparkle in the eye looking at her. Hey, what's up, law clerk? I love the way you're handling those papers, man. Staple those papers. I love that stamp. Hit it, Allison. And so the judge doesn't want people talking about his Greenfield because he's got something going on or something. I don't know. But it is an order that was written from him telling the defense team, stop commenting about her. Now, I know I'm joking about it, but I think it is a serious issue. If the judge is getting direction from the law clerk, who is the judge? Okay, who's actually conducting the proceedings? And if the judge is getting notes and getting whispers and looking to her for guidance and looking for responses to objections, we can't see what's in the courtroom. They don't have cameras in there. They tell us that this is all open and transparent, but then suddenly we can't actually see what's happening. They do bring the cameras in for about 2 minutes before the proceedings start, and then they kick us all out so that the judge and his clerk can apparently collude with one another. Here is what it looks like inside the court. Eric Trump going to be testifying, we'll get to. Alina Habba dressed in hot pink. So they will let cameras in there from time to time. But as soon as the proceedings come into play, everybody's got to be thrown out. Now let's see if they pan on over to Tish James. And we're going to see where Tishy's sitting today. Where she planted that Tishy, whether it's in front of the bar or behind the bar. Everybody's getting their camera shots in.
Okay, thank you.
All right. Did we have a Tish sighting? Oh, there's the judge. Oh, look at Judge's Greenfield sitting right next to him. And she's got a little bit of a smirk on her eyes going there. The judge is not happy about it either. I wonder if they had a conversation this morning. The judge looks fired up. He's coming out to defend her honor. Don't you talk about Allison that way? All right, let's see if Tish is here. Where's Tish? Oh, there she is. Oh, there's Tish sitting once again, in the back of the courtroom behind the bar. I don't know why she's doing that. She's a lawyer, man. She's the state attorney general. What's she doing over there? And look at her. She's staring at Eric Trump. Oh, my gosh. What a psychopath. Staring, smiling, giggling. Using her raw power of the office of the New York Attorney General to go after her political opponents. And so that's what's happening in New York. Now, there was a big fiery explosion this morning when Judge Engoron said to Trump's defense, don't you dare talk about my girlfriend, okay? She's my Greenfield is what I meant to say. Greenfield. Sorry, the alliteration gets me confused. My Greenfield. Don't talk about my Greenfield. And it is written in an order, and we're going to read through the order because now Trump's attorneys can't even see it. And so we'll get there right after a quick message from our friends. The order from Judge Engoron is right here, and let's unpack it. Judge is not happy. Some people were talking about his Greenfield. He's like, hey, that's my Greenfield. And here, this came out in an order. They said, the judge, all right, everybody, I'm angry with you. On October 3rd, after Trump posted to social media account untrue, disparaging, and personally identifying information about my principal law Greenfield, I imposed on all parties to this action a very limited gag order, forbidding all parties from posting, emailing, or speaking publicly about any members of my staff, emphasizing quite clearly that personal attacks on members of my court staff are unacceptable, inappropriate, and I will not tolerate them under any circumstances. Which is strange because we have free speech and we can't, I think, talk about people who are involved in the process, who are part of the political prosecution of people if they are actively engaged in it. Why can we not talk about that? Now, I've made further clear that failure to abide by this directive will result in serious sanctions, says the judge. On October 20th, upon learning that Trump failed to remove a post from one of his campaign websites, Donald Trump, for a total of 17 days, I imposed a fine of $5,000 against Donald Trump for violating the gag order. On October 25th, 2023, after conducting a brief hearing, I concluded that Trump intentionally violated my gag order by telling a gaggle of reporters outside the courtroom the following statement in reference to my principal Greenfield, my number one GF. Says this judge is a very partisan judge who's with a person who's very partisan sitting alongside him. Judge said that he was talking about, Trump said he was talking about Cohen. Perhaps even more partisan than he is. And so then the judge said, that's my Greenfield, and then fined him an additional $10,000 on that. So the judge writes, look, I impose the gag order only upon the parties operating under the assumption that such a gag order would be unnecessary upon the attorneys, right? So only like, Trump. Because the attorneys are officers of the court. But over the past week, defendants' principal attorneys, namely Christopher Case and Clifford Robert and Alina Habba, they have made on record repeated inappropriate remarks about my principal Greenfield, falsely accusing her of bias against them and of improperly influencing the ongoing bench trial. Wouldn't it be nice if we could see the video and comment on this and judge for ourselves? Because it certainly sounds like something weird is going on. They say Trump's lawyers have made long speeches alleging that it is improper for a judge to consult with a law clerk during ongoing proceedings, and that the passing of notes from a judge to a law clerk and vice versa constitutes an improper appearance of impropriety in the case. But these arguments have no basis. If I want to take notes from my Greenfield in the afternoon and play footsie, I'm allowed to do that. And you can't criticize anything, right? I could have her maybe just sit on my lap and just type up the memos. Now, pursuant to the New York rules, the judge is citing his own rules just to make sure, says a judge may consult with court personnel whose function is to aid the judge in the carrying out of the adjudicative responsibilities of the judges. Okay, does it say like what, every 5 minutes that you can just get notes? Because if the law clerk is acting as the actual judge or is taking over a substantial portion of the judge's duties, is that actually the judge or is that the law clerk doing the adjudicating? Like when you go to a surgeon, do they like open you up and then like pass it off to somebody? What do you think? Should I cut that or cut that? I don't know. Let me ask my clerk. Hang on a second here. What are you doing over there? What do you think I should cut? No, thanks for your input. Well, I'll call you back in 2 seconds when I got to stitch them back up. It's nuts. It's like you're the judge, right? You don't need outside influence for somebody who knows more than you do or knows what the plan is. So you can criticize that, in my opinion. Now, again, there's already laws, okay? You can't harass or threaten somebody. You can't say, go take this woman's house or something, right? That's all illegal already. Trump has not done any of that, but fair criticism about the court process is legitimate. He says, this is precisely the role of my principal Greenfield in New York courts. Moreover, ethics advisory opinions, this judge is like coping now. He's like, I can do whatever I want. You know, he's like justifying it. He's over-explaining a little bit. The relationship between a judge and his or her Greenfield is one of particular trust and confidence. Ooh, this judge. Look what he's citing. Oh, he's going to tell us about the romance here. The relationship, by the way, America, in case you didn't know. Let me tell you about Engoron and Greenfield's relationship. Here it is. He writes, the relationship between a judge and his law clerk is one of particular trust and confidence. Although a judge and his law clerk are, of course, not partners, sure, the two do engage in the kind of professional interchange. Oh, is that what they call it in New York City court clerk biz language? A professional interchange that might be found between longtime colleagues in a law firm. Well, I don't know what kind of law firm they were working at. Whoa! The judge has a professional interchange with his law clerk, and don't you talk about it. The judge he's fired up. He got busted. He knows it. He says, as I have stated on the record, seemingly to no avail, my Greenfield is a public servant who are performing their jobs in the manner in which I request. This includes providing legal authority and opinions, as well as responding to questions as I pose them, very frequently, very regularly. So plainly, Trump's lawyers are not entitled to the confidential communications amongst me and my court staff, who are hired specifically to aid me in carrying out my adjudicative responsibilities. Nor are they entitled to continue referencing my staff in the record. So the defense can't even talk about her in the record. They're not entitled to communicate about how the court is proceeding. Saying Trump's lawyers have had ample opportunity to make their record, and they've made it. They've already said that they don't like this. So indeed, I will assist them by repeating here that I will continue to consult my staff, as is my unfettered right, as much as I want, as much time as I want. Maybe they're texting each other in a Slack group or something. Who knows? Throughout the remainder of the trial, I'll be doing what I want. And so Trump's record, yours, is fully preserved for the duration of the proceedings. I took your complaints, they're filed. And so the attorneys may refer back to this blanket statement in their appeals as they deem appropriate. I don't care. Says Trump may reference my staff as is appropriate to ask about scheduling issues and to manage the trial, which is part of their jobs. But what Trump may not do is to make any further statements about internal and confidential communications, whether it's conversations, note passing, or anything similar between me and my staff. What kind of world are we living in? The judge says, you can't comment on my secret notes with my court clerk. Man, he is really irritated by this. Why is that? Because he knows that he's busted and he doesn't know what the heck he's doing. He says defendants' First Amendment arguments in opposition to this imposition are wholly unpersuasive. This gag order is as narrowly tailored as possible to accomplish its goal, which is what? To protect the notes, the note-taking capacity of you? Did he say she's under threat now? She's not even under attack, under any threat. Is anybody harassing her? Is there any imminent harm coming her way? It's just, he doesn't want them commenting about notes being passed. Okay, so this gag order is narrowly tailored as possible. Now, as I have made clear, as the judge in this case and the trier of fact, the gag order does not apply to me. So say whatever you want about me. However, I will not tolerate under any circumstances remarks about my Greenfield. The threat of and actual violence, okay, the threat of, right? None has actually happened. And violence resulting from heated political rhetoric is well documented. All right, so that means we can't say anything and criticize your Greenfield. Since the commencement of this bench trial, my chambers have been inundated with hundreds of harassing and threatening phone calls and voicemails and emails and letters and packages. Well, you probably should see if they came from the FBI. Now, the First Amendment right of defendants and their attorneys to comment on my staff is far and away outweighed by the need, by the need to protect them from threats and physical harm. Did you see what he just wrote in a court order? The First Amendment right of the defense and their lawyers to comment on my staff, which is the proceeding, is outweighed by the need to protect him by the physical harm. Okay? Just so we're clear. Judge Engoron Greenfield in his courtroom and the note-taking is so appropriate and permissible because they have professional interchanges there. Very, complicated, very special relationship that none of us would understand. And if you dare to criticize that component of what's happening, they might be under threat of physical harm, and so you're silenced. You can't criticize what appears to be totally inappropriate note-taking. He even admits it. It's like, we're passing notes this whole time. If he's the judge, then why is he getting instructions from his law clerk? Maybe she should just be the judge. So for the reasons stated herein, he's gagging the lawyers. I hereby order that all lawyers are prohibited from making any public statements in or out of court that refer to any confidential communications in any form between me and my staff. Don't you tell on my note-taking. Don't you dare report that I am getting advice from my court clerk. Failure to abide by this directive shall result in serious sanctions. It's a wild time. I mean, it's like, where is this going? So the lawyers can't comment about the process, and I'm hopeful that they appeal this immediately because the lawyers should be fired up. Every lawyer should be fired up. You can't comment on what a judge is doing when the judge is doing something that is grossly inappropriate. Well, that's what this judge did. And so we're going to get into the trial activities. Now, that is the final order. But today, there was a lot of action on the stand. And we're going to start with Eric Trump. He was on the stand, and the trial activities come over from Dan Alexander. He was back in Lower Manhattan. Now, he's going to walk us through some of this. He says that Eric Trump was in court, strolls into the courtroom, wearing a dark suit and tie, stands at the defense table, hands in his pocket. Tish is there, seated in her usual front row spot. She's got the cushion just how she likes it. Been sitting there for a lot in this trial, not standing or doing anything, just sitting. When the judge arrives in about 5 minutes, they'll get started. Judge walks in. All rise. Oh, man, stand up. All right. Please be seated. Judge scurries on up to his perch, as he usually does. He says, as the day goes on, I go slower and slower. It's Friday. Now, photographers bust in, smaller group here, 4 of them, 4 cameras. One of them has shades on. They position themselves in front of Eric. They're snapping away. They make their way out. Photographer takes his photo of Tish, and she's like smiling like a lunatic. Now, they've been here for 15 minutes, and things are already going off the rails. The judge says he hopes he was clear yesterday. He says, all right, everybody, listen. My Greenfield and I have a special relationship. I just want to be crystal clear about this on the record. I thought I was clear yesterday, but I instructed the defense lawyers to stop making a big deal out of my clerk. If she wants to pass me love notes in the middle of a trial, she's free to do that. And he says, I'm worried about this. Chris Keyes, Trump's lawyer, stands up and says, Your Honor, I know you've said something like this, but I got to tell you, this is ridiculous. I've been practicing law for however many years. This is a case of national importance. You're the judge who's been assigned to this case, not your law clerk. It's very clear based on my research, the law clerk is biased, and the entire country, Your Honor, if not the world, is watching this proceeding. He says, I can't even believe what we're seeing here. You're the judge, and this is all by the way, we, the defense, should even be seeking a mistrial. That's what he says is so bad. Judge Engoron is sitting there. He says, nice talk. Not very impressed. Okay, you say you need to make a record? Well, you've already said all of this. I've heard this like 10 times. Okay, I still like my love notes. And he says, well, I'll think about it and blah, blah, blah. So, of course, we get a ruling. And now we jump over to Forbes, where the testimony continues, courtesy of Dan Alexander. Now, we're there. He says the proceedings are finally back to business. The attorney general and one of their lawyers, not Tish, because she doesn't do anything, says, all right, Your Honor, we're recalling Eric Trump to the stand. He says, all right, walks up there. Seems like he's a little tense, they say. Looks like deja vu in the courtroom. Eric Trump says, look, I don't know anything about the calculations of the net worth, all right? I don't know. It's the same story that we had yesterday. Document after document, Eric Trump is sort of involved, sending emails in calculations. The Attorney General office now has a series of documents. They put them on the screen. They say, do you think this would present a fair picture of your father's finances? They say your signature's on there. Do you think it's fair? He said, well, I wouldn't sign something that I didn't think was not accurate. They continue questioning. They say, Eric, now tell me how we came to these calculations. He says, I don't really remember. We were reviewing methodologies on how we calculated the net worth. But they say, how did you come to the determination about whether these documents were accurate or not? He says, well, I had lawyers and accountants. So I gave it to them. The lawyers and the accountants told me it was accurate or not. I wouldn't sign something that didn't feel accurate, says Eric Trump. And they put up some other documents on the screen. Mar-a-Lago, Palm Beach, Trump lives there. AG's office put some spreadsheets up there. And they say, do you know here? They say, here's one valuation. When Mar-a-Lago was considered a club versus when Mar-a-Lago was considered a home, right? If it's a public property, it might be differently valued than a private home. Would be worth more as a private residence than a club. So now this is a big thorny issue. Of all the assets, Mar-a-Lago is the hardest one to evaluate and value. There's development restrictions on that. Eric Trump says, well, I think it probably could be converted to a residence at some point. And he says, my father said it's probably worth 1.5 bill. He says that number is pretty inflated. AG's office said it's probably closer to 75 mil, which also seems low. Forbes has evaluated it at a different rate also. So Eric Trump is now done. Comes down from the stand, grabs his lapel, walks to the center of the room, storms out or strolls out of the side doors. Cameras erupt. And that's it on the day. The judge returns to the issue about his law clerk. He's still fired up. He's like, we've got dinner tonight and she's going to be so mad at me. He says, going forward, I don't want any other comments about my staff or how I communicate with them. Don't tell everybody about our notes. Now that's it for the day. Over from Dan Alexander. But we're going to fill in some of gaps here with Adam Klasfeld, who's also reporting. And so we'll restart with saying that Eric Trump is back. The judge is in session. People are there taking photos. Engoron addresses the comments that they've never seen a judge pass as many notes with his clerk. Engoron says, well, that's not true. I know about another judge who presided over a high-profile case where a clerk was running for an election, and the clerk told me that I sit on the bench every day with the judge. I whisper in his ear and tell him how he rules. So the judge is telling a story like that? He says, but that's not this case. She's not whispering in my ear. Engoron says, I hope I made myself clear yesterday. Now, Chris Keese is unbowed, he says, fired up. He says, Your Honor, I don't know how to make a record here about our complaints. He says, do you feel the need to make further record as things stand now? He says, yeah, I think I do. Engoron says, but I don't want to endanger the safety of my staff. And he says, you can say whatever you want about me, but not my staff. Keese launches into an extensive monologue. World's watching this case. He says, Your Honor, I have read an article, by the way, about Greenfield's campaign contributions. He says, if that is substantiated, I think the defense is going to have to make a serious consideration on seeking a mistrial. If your clerk is whispering into your ear and she making campaign contributions to other people that are adverse to us, that's bias, and we're going to move for a mistrial. Says, I think we all need to take this very seriously because the entire world is watching. He says, there are two adversaries here for a third time. Engoron says, you've said all that. AG comes in, says, Your Honor, the notion that bias can be assessed by the number of notes passed between a clerk and a judge and the number of notes passed by which side, I've never heard of that. So it sounds like even the government is admitting, like, wow, they're sending a lot of notes over there. But whether it's like 10 notes per hour or 50 notes per hour, it's not a good indicator of bias, is what the government says. It says no party has a right to be privy to the internal deliberations of the chambers. That's absolutely clear. And so that includes knowing how many notes are being passed. The government is saying you can't know what they're doing. Like, you can't even count them. It says we're wasting a lot of time here with speeches. If they really have a problem, put it in papers. And the judge says, gosh, it's a shame that we descended to this level. He says, I agree. The world is watching. And Eric Trump is brought back in, and his testimony starts. They talk about Deutsche Bank, and we got most of the rest of that here. Back to testimony. Eric Trump is being shown a bunch of documents. Now, Engoron, before the morning recess, sparks fly between Engoron and Keese. Engoron warns him, hey, no more remarks about my clerk, even to create a record. If you want to appeal or move to recuse, you've got plenty of ammunition. He says, by the way, the record that you want to make would be useless anyway because the judge has the absolute right to receive notes from my staff. And if you want to make a motion at this point, go ahead and do it. You've made speeches, Chris. You've made observations. What more of a record do you want? He brings out two adversaries a fourth time. He says, and the judge is just scoffing at him. The government turns in. They say, Your Honor, this is a sideshow. This sideshow of the clerk passing notes to the judge, it's being designed to interrupt our ability to put an end to this. And if there's something improper between a judge and a clerk passing notes, you make your motion now, he says to Keese. Engoron says, I'm going to issue a written ruling later today. And now Andrew talks about establishing a record. So the government says, Your Honor, I'd like to make a record. And Keese says, oh, wow, a record? There needs to be a record? That's interesting. Chris Keese has freaking had it, man. Blowing a gasket. Rightfully so. I'd probably be doing the same. Proceedings have ended for the day. Eric Trump's testimony unceremoniously wrapped up. No cross-examination. Finished the questioning about the severance. And that was it. Now, Eric Trump did make a statement when he was exiting the courtroom, as did Alina Habba. And so let's listen to what Eric Trump had to say upon the exit. Let's fix this audio here. See if we can boost that a bit for us. Big charade and a huge waste of taxpayer money. And of course, he's right about that. It's also a disgusting abuse of governmental power. I understand the idea that this is a waste of taxpayer money. That's fine. Taxpayer money is wasted all the time. This is a full-blown attack on free speech. It's a weaponized government against a person's private businesses and public businesses. It is the weaponization of power against political opponents. That's what is outrageous. Here's Alina Habba, who's coming out to explain the same.
We are now over a month deep into the biggest waste of New York taxpayer dollars I've ever seen. President Trump's statement of financial condition was so undervalued, but Letitia James, as you've seen, will show up when it's a press day. I said it yesterday on the news. She hasn't been here for days, but you know when she's going to come? When the main event's here, and that is Trump. She piggybacked on Trump to get into office. She didn't do it well enough to be a governor. She was a failed gubernatorial candidate. And now she's working on her politics again. She shows up, sits in the back when she should be doing real work because the city of New York has fallen apart. If you are a business in New York, pay attention. You put your value. If President Trump wanted to inflate his net worth on a statement of financial condition, his brand alone could double, triple it. It's basic. It's basic. This is a waste of time. We heard testimony from an expert this week. Ms. James wasn't here for that day because it wasn't good for her. He's been paid by New York taxpayer dollars $450,000 in the past few months to come here and testify. That's your money. That's not my money. It is a crime. And now these children are being brought in away from their families for doing nothing wrong. It's a great company. It has always been a great company. It's worth a lot more than the statements say, and she just doesn't like it. And now her politics don't allow her to back off or back down. And it's unfortunate, but this case should be done. We are wasting our time. Thank you.
It's much more than a waste of time and money. It's a full-blown attack, and this is just one vector. Yes, it's a civil case. Yes, it's Trump's businesses, but it is taking time and resources and money, and Trump and his lawyers could be doing so much other things like protecting against other legal onslaughts that the Democrats are cobbling together right now. So we'll be here continuing to cover the New York trial and Judge Engoron Greenfield as this trial continues to unfold. I do hope you join us, my friends. Thank you for checking out robertgovea.com to sign up for our daily newsletter so you can get access to all of these PDFs, to the mind map, and get the show notes sent right to your inbox every single day. And we'll be looking forward to seeing you on the next one. All right. Now, we've got one final segment on the day. And so let's get right to it because I want to see what you say about this one. I think we have some squirming coming up. The January 6th committee lawyer, the counsel who was there facilitating a bunch of the interviews and all the things that made Liz Cheney very happy, was brought into trial in Colorado on day 5. And he gets a little bit squirmy here during one part of the cross-examination when they put up on the screen Raskin and Aguilar and other J6 committee members who were supposed to be fair and unbiased and impartial. But when he saw their statements and was asked about their impartiality, didn't feel too comfortable sitting there for a while. And so we're going to go through that. The guy's name is Tim Heaphy, and we've got a decent-sized clip from him with 4 different examples that he gets walked through. But first, let's talk about what happened earlier in the day. There was a long exchange involving this guy, St. Thomas of Law professor. His name is Robert Delahunty. And in day 5, we listened to a lot of him because he is the opposite of the other expert that we saw earlier in the trial earlier in the week. And they brought out the guy, I think he was from Star Trek, and he was explaining how the 14th Amendment absolutely applies to Trump and that all of the language in the 14th Amendment applies exactly to what Donald Trump did, and how Trump's statements and how his failures to act and how all of these things were justifications for invoking the Insurrection Act under the 14th Amendment and throwing Trump off of the ballot in Colorado. So this guy's coming out to explain the opposite position, and his name is Robert Delahunty. And let's listen to how the testimony unfolded in trial on day 5. And again, the audio is a little bit wonky on this one, so we'll modulate as best we can here.
Let me ask you this. Professor Magliocca also testified that the shall have engaged in insurrection or rebellion language means any voluntary act in furtherance of an insurrection against the Constitution, including words of incitement. And he based this on judicial decisions and a U.S. Attorney General opinion of Attorney General Stansbury. What's your opinion on that?
Okay, so the Star Trek guy came out and he said that insurrection, as defined under the 14th Amendment, also includes words of incitement. So that means that words of incitement, they're going to say, is Trump's words of fight like hell. Does that fall within the 14th Amendment? Do you agree with that guy from outer space?
On the use of Stansbury's opinion in defining what insurrection is.
I would have 3 thoughts, I guess, about that part of Professor Magliocca's testimony and report. First of all, I would say it's a linguistic point. I think engage in insurrection has a more restricted meaning than he supposes.
Narrower. It's narrower, less applicable.
speakers of the English language, I think this. If we use a phrase like engage in hostilities, we probably have in mind combat, not the preparatory actions that would go with engaging in hostilities. I think intuitively we would distinguish engaging in hostilities from engaging in incitement, let's say, to hostilities. So that's just a linguistic point.
Incitement versus insurrection versus hostilities. What is engagement? What is insurrection relative to these other terms?
But
And if you're at home playing the drinking game every time either the witness or the defense attorney say the word be careful.
backdrop to the Constitution's Section 3's use of engaging in insurrection. Part of it is the Second Confiscation Act, which I think Professor Magdalena cites, which itself distinguishes between various preparatory or accompaniments of engaging in insurrection or rebellion and engaging itself. That's the language of the Second Confiscation Act. And the Act distinguishes between, let's say, inciting an insurrection or rebellion versus engaging. Congress had that template before it and cut out, or at least didn't include, all this other language. And in Section 3, it narrows it to engaging.
Okay, so the language that actually showed up in the 14th Amendment is pretty narrow, right? It says engaged in an insurrection or engaging in an insurrection. Very narrow. When they were drafting the Constitution, or that 14th Amendment in particular, after the Civil War as part of the great, the Reconstruction Amendments, they had a bunch of other stuff in the first draft. You know, you send documents back and forth, delete that sentence, change that word, remove that, put that in there, add this, change that, all those things, red lines. The original version had all the other things, okay? Engaged in hostilities or organized or planned or sent letters or passed notes between the judge and the clerk in interprofessional interchanging relationships or whatever it is, right? All of this stuff could have been part of the law, but it wasn't. They said engaged in insurrection. And so this gentleman is going to bring us some more analysis and explain why the 14th Amendment doesn't apply to Trump and what they're trying to do, which is remove him from the ballot, in a second, right after a quick message from our friends. And we're back with this scholar explaining why the Insurrection Amendment, the 14th Amendment, doesn't apply because it's much narrower. It's not as broad as originally thought.
In insurrection or rebellion, which I think very strongly suggests that it was not covering the same class of activities as the Second Confiscation. So engaging in insurrection in Section 3 has a narrower meaning than the comprehensive, sweeping account of the activities associated with insurrection or rebellion that you see listed, enumerated in the Second Confiscation Act. I agree with Professor Maglioka that Attorney General Stanbury's two interpretations of statutes, the use of in the Military Reconstruction Acts of 1867. I agree with him that the Attorney General's opinions are certainly good evidence as to the meaning of engaging in insurrection in Section 3. They were opinions that were written while Section 3 was being debated and in the process of ratification. He actually, Sandra actually has a section in the first of his opinions dealing with the statutory language of what it means to engage in insurrection. So that's contemporaneous from a high officer of the executive branch. It is about a statute, but it sheds light on what engaging in insurrection means for Section 3 purposes.
And looking at the Stanbury opinions, what's your view on how he defined insurrection and its application to Amendment 14, Section 3?
So I think Professor Maglioka under-describes what Attorney General Stanbury is writing about. When in the first of these two opinions on the Military Reconstruction Act, in the first of them, Stanbury has a section called something like engaging in insurrection.
Engaging.
Well, I think it's actually called engaging. It's about engaging in rebellion or insurrection. So Stanbury says, okay, this is what he's going to explicate. This language in the statute. And he starts by saying that engaging in there you have to distinguish between active and passive engagement, participation in rebellion. Stanbury is here primarily addressing what it means to engage in rebellion, not insurrection. So
Okay, then a difference between insurrection and rebellion, and all this is called statutory history. It's what was the history leading up to the statute and the debates and all of the committee reports and all the stuff, like everything Congress looks to. What did they review? What kind of data went into this and all the things? And they define the difference. What's a rebellion? What's an insurrection? What is passive involvement in the insurrection versus active involvement? Can you be passively involved in an insurrection? Here's what he says.
You have to start, Stanbury says, by distinguishing between active and passive participation. And passive participation in rebellion doesn't count under the statute. So that's his first sort of distinction.
All right, so we're just discussing the different words and the different statutes or the different conversations, the different debates that were taking place while the 14th Amendment was being crafted. And the question becomes, was it something that would apply to a riot at the Capitol building such that Trump should be considered to have become an insurrectionist and be disqualified? Now, we get to this exchange. Now, this one is pretty interesting. So this guy's name is Tim Heaphy, and the removal team, they brought him in to talk about how the January 6th committee was done so appropriately, above board. He's got some background. They did this credential drop with this guy that, I've worked here. And they used him to kind of rebut Kash Patel's testimony that we released all the transcripts and everything was above board. Okay, we give everybody everything. We didn't hide or miss any evidence, which we know is totally untrue because they're demanding that evidence in other trials. Trump's team is doing the same. As we know, it was essentially deleted when it was on loan before it landed at the House Administration Committee. We've had Congress people investigate it. But this guy is now on cross-examination. Okay, so they brought him out. They played their little show. And now they're bringing him out, and we're going to watch him squirm. And you can tell me if you think he's squirming or not in this next 6 minutes, but certainly looks like it to me. Now, what we're going to see here is, I think, 4 different exhibits, one after another, and they're just going to put them up on the screen, and they're going to say, hey, Mr. Heaphy, now you're a lawyer. You've worked on other cases like this. You know what it's like to be fair and impartial, and we wanted the January 6th committee to be fair and impartial. We unfortunately didn't get the Republicans on the committee that the Republicans wanted. So Liz Cheney and Nancy Pelosi, they just picked 2 Republicans who are not even Republicans anymore, Liz and Kinzinger. And the minority party, the Republicans, they couldn't get Jim Jordan on there or anybody else. And so they just conducted this in violation of H.R. 503, their own House rules. And they said it was all fair and above board, even though there was no adversarial proceedings or counter witnesses or even opening statements by the other side. So then they did this. They said, okay, since you're the lawyer and you managed a bunch of this, can you tell us whether you think that the committee and their work product was in fact fair and impartial, given the fact that they made all of these statements right after January 6th, before any evidence even came in, right? This is Adam Schiff's statement on January 8th, 2021, after January 6th. So there was not even an opportunity to see any evidence. And boom, Adam Schiff, who was on the committee, the fair and impartial committee, this is what he was saying. And we're going to listen to this counsel for the J6 committee sitting and squirming in his chair.
So it says, while we were performing our duties, the President of the United States, in an unconscionable act of sedition and insurrection, incited a violent mob to attack the Capitol. See where he says that? And that, in your view, is that is consistent with someone being fair and impartial in an investigation?
I think that was Mr. Schiff's hypothesis, informed by events that he observed, but does not reflect him or others that have the first line.
Okay. Let's go to Exhibit 1095, please.
You saw those hands? Ah! Another committee member, Aguilar.
One moment, Mr. Heaphy. Can you stand up right now? It says, towards the end of the first paragraph, it says, Aguilar spoke on the House floor to call on his Republican colleagues to uphold their oaths of office by holding the president accountable and supporting impeachment. So here's where Representative Aguilar is asking others to hold the president accountable and support impeachment. And then later in the next paragraph it says, when the president sent a mob to the Capitol, radicalized by his lies about the result of a free and fair election to stop the counting of the electoral votes, he made it clear that he poses a grave threat to our democracy. In your view, that statement is also consistent with Representative Aguilar being fair and impartial in the investigation in January 6th.
Yeah, the reference to impeachment is instructed that there was a proceeding in Congress seeking to impeach the president based on some of the same facts that were issued in our investigation. I think all 9 members that voted that he should be impeached when that proceeding took place before the committee started. So yes, they had made some preliminary determinations, hypotheses based on what they saw, but again, wanted us to plug that in to test against all the evidence that we were finding. So I don't believe Mr. Aguilar or any of the others had made any conclusion other than that preliminary one informed the impeachment vote.
Okay. You see where it says Representative Stephen Murphy. I'm showing you tweets from her. Was she a member of the Select Committee?
Yep.
Yes, she was.
Okay. And here she says the president incited a violent insurrection against our democracy, proof he's unable to uphold the Constitution. Is that statement consistent with her being fair and impartial in this investigation?
Yes, I believe so.
Okay. Let's go to Exhibit 1099, please.
Perfectly fair, perfectly unbiased, totally impartial. January 25th, no evidence was even gathered yet. Raskin, Jamie Raskin, the guy who objected in 2016 to Trump.
Okay. So this says that the 9 impeachment managers will present, this is the second to the last paragraph, the 9 impeachment managers appointed by the House of Representatives will present overwhelming evidence of the facts of former President Trump's incitement of the violent insurrection that took place in and around the Capitol on January 6, 2021. Is that statement consistent with Representative Raskin's ability to be fair and impartial as a member of the committee?
Yes, that is asking led the impeachment proceeding as the chief prosecutor, if you will. But I don't believe that made him closed-minded about the overall factual circumstances that gave rise to those actions.
Okay, so even though he said there was overwhelming evidence, and even though he said there was overwhelming evidence that President Trump had incited violent insurrection, and even though he actually led the prosecution of President Trump, you're saying that he remained fair and impartial in determining the conclusion in investigating and coming up with conclusions on the January 6th Select Committee. Is that correct?
Yes, because the goal of the January 6th Committee was not about the culpability of any one person. It was about the overall facts and circumstances that informed the attack, all the various components of it. The president's incitement of violent insurrection was one among hundreds of facts and circumstances that were considered. And even that, if there had been contrary evidence, we would have presented that. So I don't believe any of these statements about this one fact among many represent that any of our members were, to use your term, closed-minded in the approach to the investigation.
No, they were not totally open-minded, okay? Not closed-minded at all. And so he felt a little squirmy to me. You'll have to tell me what you think about that, but certainly looked a little uncomfortable when he had to defend those statements. Why? Because they're indefensible statements. It was obviously a political attack job, and now he's got to sit there as a lawyer and say, no, they could set all that aside and be fair and impartial. It was a bunch of people on a mission to take out their political opponents, which is why I think they set the whole thing up to begin with. And we see now he gets examined during day 5 of the Colorado trial. We'll be back next week for another week of this, and I do hope you join us and subscribe so that you don't miss anything that we're doing here. And we'd love it if you checked out our website, robertgovea.com. The link is down in the description, where you can sign up for our daily newsletter, get all of the various segments that we cover here delivered to your inbox, where you can download the links, read the reports on what the video covers, and we'll be looking forward to seeing you there and on the next one. All right, my friends. What a witness, huh? We covered some good ground today. We got the January 6th committee. We got the counsel. I think he's squirming in there. We've got Engoron, who is gagging the Trump lawyer, saying, don't talk about my Greenfield. Don't say that we can't pass love notes to each other. And of course, the emergency appeal, which was filed and granted, temporary administrative stay granted. And so we'll see if Donald Trump has anything to say about that. But my friends, now it's time to hear from you and to see what you have to say about this over at watchingthewatchers.locals.com, which is our amazing community where you can come and join us. We do members-only streams in the morning. Tomorrow's Saturday, which means we do Saturday streams. And if you want to catch us in the middle of the week or earlier in the day during the week, we do streams. We already did a stream this morning, and we've got a lot of business to talk about, right? Right now on the main show, we're covering Trump stuff. But there's a lot of other stuff that we get to at watchingthewatchers.locals.com. It's a great way to meet people. It's a great way to support our work, and we'd love to see you there. Also, if you're a YouTube member, we got a bunch of new members on YouTube who joined us. Make sure you grab the Telegram link. We're going to say what's up to Dolphin and welcome everybody. But grab the Telegram link, scroll over on the channel on YouTube, navigate to the community tab section, get the Telegram link. We'll see you there for the after party. Also, our website, robertgovea.com, my friends. Check that out. Sign up for the newsletter, get access to the PDFs, grab the mind map. There's a tutorial video on how to use the mind map once you sign up so that you can learn how to use it, navigate around just like I do. And so let's see who is in the house and checking in with us today on this lovely Friday. This one is from Quarter Native, and this one caught my eye. I was laughing about this at the start of the segment. Find someone who looks at you the way that Engoron looks at Greenfield. I love the way you use our stamp, Allison. You're so beautiful to me. What's up, Quarter? Too funny. All right, I was laughing on that one. All right, we got another one. Who else do we have? Let's pop open the screen. We got Ignacio. What's up? Ignacio V is here in the house. Welcome to a supporter, my friend. We're glad to have you. And we'll see you in the morning for our Saturday stream. Hey, brother's here. What's up, brother? Good to see you, my friend. Welcome as a supporter on the tubes as well. We'll see you tomorrow morning. Indeed. We've got Dolphin Fan is the man. And oh my goodness. So Dolphin, we got 2 donos from you. We got some serious donos in the house from Dolphin. Says, hi everyone, Dolphin Fan. I hope you are doing great. 3 exclamation points. Says, I want to wish my amazing wife a happy birthday. Oh, shoot. It's Dolphin Fan's wife's happy birthday. Happy birthday to Mrs. Dolphin Fan in the house. Hope you're having a beautiful day. You're married to a heck of a guy. We like him around here. And he's very, very supportive and contributory to our community. And so let me just say, courtesy of Dolphin Fan and Mrs. Dolphin Fan, big welcomes to all of these membos. So let's celebrate the birthday together by welcoming all of these new membos, courtesy of Dolphin Fan. 50 membos. Happy birthday party in the house here and at the household of the Dolphin Fans. We got Muffin Rando, James P, Tom C, Lowell S, Saffon, Stina M, Object Class Keeter, that's a big one, is here. James Beaver, we got Toenail H, Toenail H, Tyler, we got Suzio, Scott M, Belinda G, Cheryl P, Mark G's here, C-Dub, we got Clyde B, Ian M, Unsound Engineer, Purple AJ, the People's Council, Snake Pliskin is here, that's cool, Adam K, Chris Sawyer, and Gen X Boomer are in the house. But that's not all. We got 50 membos coming in. We're just warming up. We also got, who's here? Just Cause, modding down the fort, welcome. Ghost is here. Pamela F. Keister Bunny. Greg Erickson's here. We got no mandates, not a Fed. That's, well, hopefully that's true. BMO. We got Steve G. We got Carrie. Bullwinkle Sprinkles is here. Eddie C. Anna D. Brenda F. True Americans here. Damon W. Hooters, Yum 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 is in the house. Welcome to Hooters, Yum Yum Yum. We also got Wrestler Town, Last of the Yahoos, Kama Sutra, Mrs. Hayes, Deb H. L. Rassam is here. NV Cruiser, Jop L. and Zach Guy is also coming in. And that is a lot of membos in the house. Oh my goodness. Courtesy of Dolphin Fan is the man. And a big happy birthday over to Mrs. Dolphin Fan. Amazing wife. Happy birthday to the household. Whew! That's a lot of fun. Happy birthday, everybody over there. And hopefully having a beautiful Friday. Celebrate away. We're all sending good love and energy your direction. Thanks for bringing in new membos into the chat. Very cool. All right. And that is Dolphin Fan is the man. And of course, that meme comes over from Jigum Gigum. What's up, Jigum? Jigum's here. Good to see you, Jigum. Says, hi, everyone. I have to say, I've been listening to the Colorado case in the background while working today, and I'm feeling pretty hopeless with where things are going in this country today. You know how Trump used to say, we're going to be tired of winning all the time? Well, I'm not tired. I'm not tired and could use one just about right now, a win. We'll just have to keep on keeping on. They win when we give up. That's a good way to end that comment, Jigum, and I think there's some inspiration in that. You know, and look, I get it. I know it's hard. We go through, what we're watching right now is not good at all. It's not good. You know, I know we can sometimes come here and kind of be jovial about it, but it is serious stuff. And it really is, in many ways, heartbreaking for somebody who loves the law, loves America, loves freedom and the values. You know, I know that we believe similarly that we've reached this era of humanity, of human existence, where we've been able to codify into our Constitution some principles that are immutable, that are natural, that are God-given. Things like free speech, things like due process, things like property rights, things like you can't have people quartered in your home, you know, and you have the right to engage in a conversation about your own destiny and all these things. And then we have people who are just taking them away at every turn because they don't understand the sacredness, the sanctity of these very important principles that exist in our world. But, Jigum, what I think of in this journey is that the truth is literally a part of the universe. It's a building block of the universe, okay? Truth and knowledge, and I know this sounds weird. If you want to go back and look at this in a quantum level, go read David Deutsch. I highly recommend it, but it's too smart for me. But the point is, there's optimism built into the universe. There's knowledge and truth that's built into the universe. And you can, tie that to physics, or you can tie that to religion or God or whatever. But the people who are on the side of truth are on the side of winning. They are the victors in this long epoch. As long as you keep fighting for that, as long as we can keep communicating, as long as we can keep building together and keep engaging in this dialogue, not get overwhelmed, not get too stressed out so that we get unplugged, so that we get stepped aside and go, indulge in whatever useless, meaningless garbage out there, that's when we lose. We're going to be a part of this process, which is self-actualizing, building lives while the world is changing around us. But that's how we're going to win, and we are going to win. So I know that things often feel, down, and this week has kind of been a rough week. We got 3 trials. They're all looking rigged, but they're exposing who they are. They are revealing to all of us what they're doing. So we're going to keep that optimism here going, okay? We're going to hold attention on that. And I know, Jigam, you're going to be here with us doing the same. So we are grateful for you. Thank you for the dono. And have a great weekend unplugging. We're going to be back, just like you said, keeping on next week. We're grateful for you, Jigam. Thank you for being here. We got another one coming in from Brian S. as a supporter. Welcome, Brian. We're grateful to have you in the supporter community. Hey, Jigam is, here's this one. Rob is on fire today. I was a little, I get irritated, man, about all this corruption, man. I can't take it. That's from Jigam, our meme smith. Thank you, Jigam. And here, Knox Bierman's in the house, an attorney over in Texas, says, death by 1,000 ums. Oh my gosh. Those two, it was bad. Those two were like feeding off each other. I wonder if they had a competition of who could say more ums in court. Like that scene from Super Troopers. You know why I pulled you over, meow? All right, you need to step out of the car, right, meow? Are you saying meow? Was it that? Like, did they have a bet? I don't know. Anyways, yeah, I agree. I almost died. Here, Knox says, this is how they're going to win. They're going to bore us all to tears so we can't see the names on the ballot. We're just like, okay, just take them off. Okay, whatever. Just take them off the ballot. You're right. You're right. My ears are about to explode. We got this one from Fred Pedamonte. Says, and it's not, and we're not doing a ritual here either. What's up, Fred? We got Pinochet's helicopter tours. Says, can any of these corrupt judges, clerks, or staff be FOIA'd for any communications between the special counsels, DAs, or the Senate Judiciary Committees? No, I mean, they're going to say that they're all part, there's exclusions to FOIA, that it's part of ongoing thing, or national security, or, attorney-client executive privilege, or any other thing. So, Judiciary Committee, right? Legislative protections. And no, I think judicial privilege would apply to the notes and stuff. That's the point, is like the attorneys need to be able to call that stuff out. Like, the defense needs to be able to identify problems with the process. Like, if the clerk was handing the judge a stack of cash or something, although that, that would be more legal, but you don't know what's in the notes. You don't know what she's saying in the notes. Like, a stack of cash would obviously be illegal, or like, but we don't know what's in the notes. So how do we know what's going on? And you can't comment on that, is my point. We got Dim Sim is here. What's up, Dim Sim? Says, Alina, Abba, in the house, Alina. And she was wearing that hot pink today. Did you see that? B-Man says, Trump's lawyers should have asked witnesses if they can impeach after January 20th. Fireworks in Florida. Well, I think that was part of the question. I mean, if I remember the timeline correctly, didn't the impeachment trial actually complete when Trump was out of office? I think, wasn't that part of the question? Like, can you convict a president of insurrection or impeachment? Can you, can they be convicted of impeachment after they're out of office? I don't know the answer to that. What's up, B-Man? Thank you for the dono. Teeny BB, what's up, Teeny? Says, how do we stop this madness? Cray cray. Been a member for 3 months, 1/3 of the way to a baby. First month's the hardest. Next month, it just gets easier every month from there. And we're glad that you're here. I don't know about that. I don't know if that applies to pregnancy. I think it's the opposite for pregnancy. But for our members on community here, I think it works that way. Anyways, cray cray, and a face palm from you, Teeny BB. I agree. Vote in giant numbers. And stay engaged. I think, honestly, we have to stay engaged. If we get deflated and de-energized, it's game over. Kelly is here. What's up, Kelly? Says, someone needs to do that meme of Lord of the Rings with the King of Rohan and Wormtail, Engoron, and the Clerk. Well, I'm sure somebody is highly capable of doing that. We do have some meme smiths in the house. That's from Kelly R. Engoron and the Clerk. There's a lot of romance novels. I was thinking maybe the two of them, when Matthew McConaughey and some woman like lean against each other in the movies, like Judge Engoron and what's her face, the blonde woman that they do all the movies together. Whatever, Engoron and Greenfield, like they get lost at sea or whatever. So this is from Patrick Kennedy. What's up, Kelly? Patrick Kennedy says, Trump versus Colorado closing arguments will be on November 15th. I already watched it live. Man, Patrick, are you from the future? How'd you do that? Do you have a stream? Do you have a link? Give us a link. I want to watch it now. I don't want to wait until the 15th. All right, so it's probably coming up on the 15th. Planning on watching it live for Patrick Kennedy. Good to see you, Patrick. We got this one from Spawn Dog. Says, do you ever talk to Miss Faith anymore? No, I don't. I wish her all the best. I hope she's doing very well wherever it is she has landed. And so thanks, Spawn Dog. Silver Manic Attack says, welcome to support. Well, welcome. You didn't say that. You are a supporter. Welcome to our supporter community. And Tony Hay Munkets says, the only one that that says more than these guys is Bill Gates. It's a sign of lying. So is going for your water. Is that true? I think it's kind of the fidgety, and when they get fidgety and they catch themselves being fidgety, being fidgety is one thing, but if you're being fidgety and then you catch yourself being fidgety, which is what I saw, then you're busted, right? He was he's scratching, he's like, oh, nope, don't do that. Adjusting, nope, put your hands back, right? I don't know if somebody was in the room with him or what, but yeah, it looked a little squirmy to me. This one from Catania Mama Italia, 8 months and counting, man, about to pop. Says, lawfare against Trump is the new grassy knoll. Well, yes, and it's a political assassination. Yeah, I mean, I don't doubt it. It's 4 indictments, lawfare, ballot removals, all over the place. It's reprehensible what we're seeing, but it's what we're seeing. We'll be here to cover it. Good to see you, Catania Mama Italia in the house. My friends, thank you for those amazing donos and all the support here. I really appreciate all your contributions to our work. Would not be possible, of course, without you. Let's say hello to our friends on the X platform and see if anybody's watching over there on this incredible Friday. We got 10 viewers. Okay, we're still in double digits. See if, drops off any, probably be back down to 4 next week. That's all right. It's a work in progress. Danny says, what's up, Danny? Says, again, I ask, why have the lawyers all over the USA not sent letters to Congress over this judge? Well, it's a good question. I don't know that lawyers want to get involved, or lest they lose their license. Rob, would you like to have an interchange with Alina? She's married, Fred. She's married. Old drill sergeant. Okay, old drill sergeant says, could you use a link? Could use a link to the Watching the Watchers community on the X? I can't find it when I search for it. Well, that's weird. All right, so yeah, well, it's. I was going to tell you it's right here. Just click the link on my link. It's not going to work for you. All right, so here I've got the link, and let's hit the back button, and let's drop this right in the comments. Boom, for old drill sergeant. We're just going to drop it right there. And if you want to join the, oh, there it is. Well, somebody already did that. Thank you, Rebecca. Boom. All right. Well, I'll just press it again as well. So somebody already, see how helpful our community is, man? It's already there. Rebecca John, thank you for doing it. All right. So there it is. And so come and join us. That is the Watchers community on the X platform. John McGarvey says, hashtag Greenfield. Hashtag Greenfield. Judges Greenfield. Colorado ballot trial has, I think, wrapped up, closing arguments to be made, which is TBD. Oh, it's done, is it? Oh, okay. So I didn't realize they finished today. Rebecca John got it hooked up. George says, I love my wheatgrass shot of Watching the Watchers. Give a big thanks to your whole team. Been watching you for about 3 months. Y'all give me such good freedom from constantly scanning the news. I know where I'm going to get concentrated juice of the most important political news here. Man, that's a nice comment. Thank you, George. Bernie says he actually shook his head no while answering yes. Yeah, the body language on that guy would be certainly fun. Some body language expert should do something on that. If the judge didn't want to be criticized, he should have recused himself. If he can't handle the heat, he shouldn't be in the kitchen. Shouldn't be cooking in the kitchen. And so that, my friends, is it from the X over on the X platform. Of course, you can come and follow us over there. We're also posting our segments now on the X platform. And so if you want to give us a boost or a retweet or drop a comment, you can see We're post. Hey, that's our that was our Halloween. That was our Halloween segment. All right. So if you're wondering why it's a little dark in this segment, it's because I was hiding from the children. Okay, I had to turn the lights out. All right. So Ken Buck testifies. You can see all the segments are there. So feel free to drop a comment, hit a heart, hit a retweet, and find each other down there on the X platform. And yeah, we're having trouble finding it. Maybe I should link it into my profile. All right, we'll figure that out. Anyways, my friends, that is it for us on the day. We had one more dono come in, courtesy of First Amendment. Says, ups from First Amendment. Thank you, First. Good to see you over on the locals, which is where we're going right now for our members only after party. And so if you'd like to join us, we're going to hang out and debrief some of today's activities at watchingthewatchers.locals.com. Members, whether you're on YouTube or on Locals, we have a Saturday stream, so we'll be back tomorrow to say hello and see what the weekend has in store for us. And of course, our website, robertgovea.com, another good place to check out the daily reports and sign up for the newsletter. Before we wrap up, we want to say thanks to the mods and the meme smiths who mod down the fort for us and keep things nice and orderly all week long. Hey, we had a couple donos come in. Speaking of the mods, Donut Mind Me just sent this one in, clipping for us from Crash. Crash is over on the locals. He says, all right, everybody. Freedom is never more than one generation away from extinction. We didn't pass it along to our children in our bloodstream. It must be fought for, protected, and handed on for them to do the same. Or one day we will spend our sunset years telling our children and our children's children what it was like once the United States, what it was once like in the United States where men were free. President Ronald Reagan. Rob, these are our sunset years. Well, when things are cyclical, like I reject the downfall of American freedom. Like I reject that, right? I'm not giving that up ever. So I'm not sunsetting anything. The point is that some people will. Now, we don't all have to go into the world of freedom together. I truly believe that there will be a giant group of people who are perfectly fine being just, mindless tax cattle and following whatever Gavin Newsom tells them to do for the rest of their lives. Insert this, turn this on, plug yourself in here, whatever. And that's fine. They're free to do that, right? We're not saving everybody. We can't, don't intend to. So for the rest of us who do like freedom and who want to be and live with and congregate with and build communities amongst other freedom-loving people, we're just getting started, baby. We're just warming up. And so, Crash, we'll see you there. Teacher Man says, if they take Trump off the ballot, we can still write him in, right? Yeah, but he's not going to win if that's the case. I mean, the idea, you'd have to get write-ins, like just the simple friction of having to write something in, I think would reduce, I don't know, if I had to guess, 20% return is what I would guess. Just as a practical matter. But I think you're right. We certainly could. And so, my friends, thanks once again for those amazing donos. And Donut Mind Me, thank you for clipping today for us, my friends, and all week. Donut been clutch this week. Thank you. Dog Digger also in the house. Janek, John Allen is here. Zach Nichols, our friend Beyond Geo. Zulu's here. Ronnie Cole, our friend Playing Hooky. Just Cause. K Bean helping us out always. And our friend Vienticus Prime modding down the fort for us. Grateful for everybody and your help. Thank you. We've got Meme Smiths, Geegum Geegum, memeing it up for us, Nathan NA10, and our friend Sleepy Dog Lee over on the X platform. But, my friends, that is it for us on the day. It has been a very busy week. We're covering 3 trials now. We probably got another one we're going to add in there soon. And so, it is now time for us to unplug for the weekend, to get outside, to get some fresh air. The weather's changing. We get to pause a little bit, take a break from all the political and legal madness happening all around the world, spend some time with friends or family, get some fresh air, some sunshine, some vitamin D, recharge the energy batteries, because we are going to be here next week to do it all again. And we need to be ready and charged to go so that when we are back here, we can get into it, and we need to be back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends, and an amazing weekend. I'll see you right back here on Monday. Bye-bye.